Welcome back, everyone, to another episode of the SERMAPod. This is the podcast of the Sports and Entertainment Risk Management Alliance. I am the founder and CEO and also the host of this podcast, Rich Lenkov. We are very privileged and pleased to have a return guest, Bryan Sullivan from Early Sullivan in Los Angeles, to discuss this time the very interesting controversy surrounding an episode of South Park involving the Royals, ex-Royals, maybe. It's not clear, Bryan, what we should call them. But welcome back to the show.
Thank you. Thanks for having me.
So this episode of Meghan and Harry discussed, not really discussed, but kind of lampooned them and showed them on a privacy tour, worldwide privacy tour, as it was called. And it kind of mocked them for alleging violations of privacy, while also doing every show, right, known to man and having a Netflix series. And what was reported in the media is that their lawyers have been looking into a possible defamation claim or some other lawsuit against Comedy Central, the network that distributes South Park, and perhaps the producers and showrunners from South Park. We know from past experience that Meghan and Harry are not adverse to litigation. But you have been quoted in lots of media as saying that you think that this would be a terrible idea by Meghan and Harry. Explain why.
Well, first of all, the target is not a news organization or anything that puts facts out there. South Park is widely known as parodying real life, making jokes out of people, and your phrase calling it lampooning them. It's exactly what it is. It's making a joke out of what they're doing. It's not saying they did something bad. It's not saying they didn't say any facts about them. They literally put a caricature up and, were more inspired by their conduct to create this joke. And I think that South Park would have an extremely strong parody defense and also which is part of fair use, but also a fair use defense.
So break that down for us. What are each of those defenses? How do they, how do they work, and when would they be successful in each of those cases? Parody and also fair use.
Well, let's start when they would be successful, because that's the most common thing that I get from people when they say it's fair use or it's parody. It's a defense, so you would likely maybe win on summary judgment. I doubt a win at an early stage of the case. You'd have to take it all the way to the end and put facts up to show that it's parody or fair use. Parody is basically what I said. It's making a joke. It's taking something that is real and making a joke out of it. No difference than what happens on Saturday Night Live with politicians, that they do to politicians all the time. And again, South Park is a comedy show on Comedy Central, animated. So it has no basis in fact. Nobody could actually assume that this is based in fact, and no factual statements were made about them. Fair use is a doctrine that allows you to use copyrighted or trademark material, and it's also bled into the right of privacy and right of publicity, where if you meet certain criteria, which I don't remember all of them off the top of my head now, but you won't be held liable for infringing copyright, trademark, or a person's right of publicity / right of privacy.
Now, parody isn't an absolute defense, correct? I mean, there are certain occasions where even a cartoon, which is almost the definition, in this case, of a parody, especially when you consider South Park, right? Its whole, raison d'etre as being a parody. But that's not always the end of the story. You can still be engaged in parody, but also be, in violation or you can still be successfully sued, in this case, for defamation, correct?
Yes, it's not an absolute defense, and you do have to prove it. So as a wild example, say you take a public figure and make them out to be a pedophile preying on 7-year-old kids. That parody, because parody is known as having a basis in fact in some fashion. So if you're trying to say that, somebody could feasibly be held liable from a cartoon, because that is a horribly heinous act to be accused of. That's usually a go-to example for defamation lawyers of the kind of case you want to bring as defamation, because it's so clear cut. But in this case, they're not basing anything on fact except utilizing the public profile that the royals have curated for themselves by publishing books, by going on Oprah, by having a Netflix series, while simultaneously out there vocalizing their desire to have a private life. Like the juxtaposition of throwing yourself in the public eye while claiming you want a private life is what the parody is poking fun at. And those are facts that are well recorded and documented.
Now, one of the reasons you've been quoted as saying in explaining why this lawsuit would not be successful, this potential lawsuit, and in fact why other potential celebrity litigants don't get into this battle is because really twofold. Number one, it's very expensive litigation. Now, these royals or ex-royals, Harry and Meghan, we know that they have signed very lucrative deals with a number of organizations, including Netflix. Harry just wrote a very successful book. But it's very expensive. And number two, it really opens up a deep dive through actual discovery, legal proceedings, but also through the media into your private life. And for two people who are, again, interested in their privacy and who moved out of the UK to maintain their privacy, that would be contrary to filing this lawsuit, yes?
Yeah, absolutely. And it, especially in a lawsuit like this, because it's not over a single fact. It's kind of over a lifestyle or at least public image that has been curated. So you'd be opening yourself up to they'd be opening themselves up to broad ranging discovery on their lifestyle, on their deals, on their press, everything they've ever done with publicity in the past couple of years. Would be fair game for anything. It would be different if, you said on such and such a date, Prince Harry purchased drugs and did all this illegal conduct. Then it would be limited to what was Prince Harry doing on that specific date. So, but this type of claim would be very broad based into your entire lifestyle.
Bryan, you work with a number, and over the course of your very distinguished career in entertainment law, have represented a number of artists, content providers.
Yes.
When you do so, how do you work with your clients, your artists in particular, to walk this sometimes narrow line of expression and artistic production with the risk of being sued?
I actually go and find the cases where people were held liable for defamation and use those as an example and then show them cases that have been found. And I explain that it's not a bright line test. It's not yes or no. It's this gray area, and who knows what a jury's going to do inside that gray area. But the more you gear towards the cases that found no liability, the better you're going to be. And then I always like to have a lot of times they call it clearance, but they usually mean for trademarks and copyrights and stuff like that. But I also often recommend that clients do an opinion of counsel letter on whatever they may be doing, so that at the very least you can be called what's an innocent infringer, or at least it's not reckless defamation such that you're below the actual malice standard, which is basically for a public person like the royals, you have to have either intentional engage in intentional conduct in stating false statements, or reckless indifference to the truth of the facts. And if you try to steer towards that, you're more likely to prevail in any lawsuit.
Yeah, it's really interesting because, I have some first-time experience with this, not only as being an attorney in the space, but also as a producer. I produce some content, some films, some theater, and in one of our films, actually the one that's the documentary that's on the poster behind me, we went through that process, and we did use some material, and we had to, of course, as you explained, get clearance, and we also got an opinion letter, a fair use opinion letter, like you said. But I'm interested, when it comes to a TV production, on a film, it's a longer production, and you've got some time, presumably, to go through that process. I wonder how that works on a TV series like South Park. I mean, they do probably, tape a lot of them in advance, but do you have to go through that process every episode, do you think? I guess it depends on the content. For an episode like this, you would be a little bit more, careful in getting that clearance. But do you think they go through that process on every single episode?
If they did, there'd be a lot less lawsuits being filed. You usually spot where the most problematic are, because some jokes are just offhand jokes. But on something like this, I would assume that, either a studio attorney, or I think it went to streaming. But some attorney definitely did a review and provided maybe not a formal opinion of counsel letter, but at least an opinion that, this is, in my opinion, this falls into parody. Here's briefly why. And then they can flesh out the longer opinions if need be.
Yeah, I'm sure they have a really strong insurance policy. You never know how much you need insurance till these issues come up, right?
Well, and the bigger issue, as I try to explain to clients, is it's not really the liability that kills you. It's the attorney's fees. And if you have insurance, you can have attorney's fees covered, at least a portion of them. And my favorite thing is when clients complain that their deductible is $125,000. I'm like, why didn't you check?
Right.
Your broker, you just told your broker to get you the best deal possible, which for you meant cheapest premiums, but that's not usually the best deal possible.
Absolutely. Yeah. And you never appreciate that till you're sued, and then it's too late at that point.
Yeah. And I mean, speaking from personal, like my firm's been sued for ridiculous things at point, out of fee collection matter, and then they sue you for malpractice because they're trying to stiff you on fees. And suddenly, by the time you settle the case, you shelled out all the money for, the defense to meet the deductible.
Right. Yeah, it's really interesting. So these particular would-be plaintiffs, Meghan and Harry, they're almost, it's sort of a wag the tail situation, or wag the dog situation, because really by even contemplating or letting the public think they're contemplating this lawsuit, it really compounds the perception out there that they're a little bit nuts, right? That they're a little bit, first they moved out of the UK to avoid the glare of public scrutiny, and now they're thinking of suing a cartoon, South Park. Like, just get over it. My point is that by even us, the public, contemplating this, it probably has more of a damaging effect on their character than this TV show did.
Potentially, certainly, potentially damaging on their popularity, which would affect their ability to get their deals in the future and sell future books and do additional television shows on their Netflix deal, and whether their programs will be greenlit in the future. In fact, being parodied on a show like South Park, I think would be more of a badge of honor than anything else. Like you've made it. Absolutely.
Last question we have for you here on the SERMAPod, Bryan, and we just covered, another high-profile defamation case, Brett Favre against Shannon Sharpe and Pat McAfee. Do you think the trend of celebrities pursuing defamation actions is growing, staying the same, or receding?
I think it's growing. I've seen more and more of it, and sometimes people are kind of like, if the defamation has become so bad, and sometimes it's more perception than reality, but they feel, well, I've got nothing left to lose. I've just been raked over the coals. So opening my life up to privacy, to discovery and all that, it just doesn't matter anymore. And, with some of the judgments that have been handed down, like in the Johnny Depp Amber Heard case, I think he was awarded $15 million, and even though she was on the other end, got $2 million. I think people see it more as a potential way of obtaining money and curing your image in the public mind. I'm still not sold that it does that, but if you've been raked over the coals enough, you kind of have nothing to lose.
Really interesting stuff. We'll continue to follow this story. And Bryan, please come back on the future on this and other entertainment law issues. That's Bryan Sullivan from Early Sullivan. Thanks very much for joining us on the SERMAPod.
Thanks for having me.